If I had to pick the overarching lesson of your book, Legal Writing, A Judge's Perspective, it would be do not fatigue your reader. So, for example, I picked that up right on page 1 of your book. When you make the observation that legal writers should always bear in mind, you say, quote, legal writing is typically read out of obligation, end quote. And I thought that was such an excellent observation. I'm always going to keep that in mind now. And in your chapter on sentences, talking about how to craft an effective sentence, you offer several ways that writers can ease the reader's burden when working through their briefs. And I just think this is such excellent advice to keep in mind, particularly when writing for a judge who is not coming to your brief because they picked it up in the bookstore and it had a thrilling looking cover and great blurbs on the back. It's because they're paid to do so. So I wonder if you could you talk a little bit more about having to read out of obligation? What are you looking for? What kind of things really turn you off when reading a brief?
Well, one of the things that does turn me off, and I think would probably turn off most judges, is personal attacks on either the opposing counsel. And it's really surprising as an appellate judge how often there is advocacy that I think sometimes maybe crosses the line in criticizing the district judge or the magistrate judge who's acting on behalf of the district court. Now, you're always, as an appellant, you're always going to be criticizing the substance of what the district court or an agency has said as an appellant or in a petition for review. But it's surprising sometimes that there's an implication or sometimes even an accusation that the judge is biased and that unnecessarily. Now, sometimes you are asking maybe for reassignment to a different judge, and you really have little choice but to say that the judge is biased. And I'm putting those situations to the side because that is relevant. But sometimes it's just an accusation that the judge is intending to get it wrong, is intending to favor one side or the other or on the tape. And that is just so counterproductive, just as it's counterproductive for an advocate to personally insult the opposing counsel, because the judge is not King Solomon. The judge is just trying to decide what is legally correct. And if you think about the goal of the reader, a judge trying to get the legal decision correct, accusations against the district court judge or even the adversary or the opposing party oftentimes is counter to the purpose of the judge. And so I think that that is probably the number one pet peeve that I have, and probably I don't purport to speak for other judges, but I suspect a lot of judges say the same thing.